Hello, good afternoon, and welcome to the Law. This is your legal light. It is your health law. I'm Samson Lardy Anyenini, and this afternoon, as advertised, we have right to information appeals to be assisted to do that conversation by Genevieve Shirley Latte, Esquire, who is the Executive Secretary of the Right to Information Commission, but unfortunately we are unable to bring you that first part of this discussion because of circumstances beyond her control. And so we have a second segment as advertised as well, the Future Fit Lawyer, Embracing Technology and Service. Isabel Boateng, the President of the Ghana Bar Association, Accra branch. She will join us because there is a law week to be had, and in that law week, that's what they are looking at, the Future Fit Lawyer, Embracing Technology and Service. Whilst Genevieve Shirley Latte, Executive Secretary of the RTI, or Right to Information Commission, is unavailable, let's begin to have an interesting discussion. In the course of the couple of weeks now, really, one issue that has dominated the media, and that has been on the top of your mind, has been about whether or not, we can have trials in absentia. That people who have or who are being sought after by law enforcement, the OSP, NIB, the Attorney General, or police, whether they can decide that, well, wherever they are in the world, let them be. We'll go ahead and have a prosecution, a trial without them, in absentia, so to speak. So let's use this time more profitably. I'm going to try to give you some education, and of course, we'll open the phone lines. You can join us, and I'm hoping that today, more particularly, lawyers will join, because many lawyers will want to join and to hear more about the Future Fit Lawyer, Embracing Technology and Service. So we will put our heads together to try and give you some education. Platinum one, of course, as we always do on the law. I'm Samson Lardy Anyenini. We'll be right back. Welcome back. This is the law. It's your legal light. It is your health law. And here we try to help you with good legal education. Education that is devoid of all of the influences that sometimes ignore the purity of the law. The influences politics, partisanship, the extreme partisan politics that influences a lot of the legal discussion or discussion of legal issues in this country. So, in the absence of the scheduled discussion, which we are unable to do for the first part because the RTI Commission's Executive Secretary, Shirley, is unavoidably absent now, let's look at the question of trial in absentia. What exactly is trial in absentia when we say we can have a trial in absentia? So the Latin expression simply means trying someone in their absence. So that's very simple to understand, right? It's like when we say prima facie, that Latin expression, it means on the face of it. We just pick something, we look at it on the face of it. When we say try in absentia, the words in Latin actually try to give you an impression in English. We're trying you in your absence. The question we want to ask today is, does Ghanaian law permit trial in absentia? If it does, when will the court or law enforcement begin a process known as trial in absentia? You know that the debate has been ignited over the pursuit of former Finance Minister Kenneth Ofori-Atta by the Office of the Special Prosecutor, the OSP. So for some months now, the OSP has been after the Finance Minister to come answer several charges relating to corruption. And it's become clear that whilst the OSP started seeking Ken Ofori-Atta sometime in February or so, or January of the year, he had left the country. He was not in the country. And so, because he was absent, his lawyers attempted to have a conversation with the OSP by correspondence to say that he's unavailable, but he will make himself available around this time. He will make himself available later. I think it began by a request that he's not available, but we, his lawyers, are available to do whatever you want to do with him. And the OSP was emphatic that no, I cannot have you, it must be him. Then the discussion turned into, okay, the OSP needed specific commitment as to time when he can make himself available. Eventually, he communicated through his lawyers that he'll be available in June, on the 2nd of June. And once that came up and he was unavailable, the OSP made the announcement to the world that he was going to put him back on the wanted list, and Interpol red alert. Initially, that's where he had been put, on a wanted list, but through the persuasion and convincing through his lawyers, it took him off that list. And since he was unavailable, he put him back on the list and declared him a fugitive from justice. And that became the debate. And you would have heard that the political divide, those who support Ken Ofori-Atta more particularly, have been insisting that he has indicated that he could make himself available via Zoom or virtually available. You want to interview me through a virtual process. The OSP says, I'm not going to have any of that. You must be personally, directly, fiscally here to do the process. In the absence of that, he's declared him a wanted man. So now processes are going to be triggered so that Mr. Ken Ofori-Atta may be arrested, extradited, and brought to Ghana to face prosecution. You have heard the debate that the OSP does not need him. He should just go ahead and go to court. With or without him, he can proceed. So that's what is bringing us to want to take advantage of this opportunity to attempt some small education. So let me begin. This book I'm holding here is what we call Act 30. It is called the Criminal Procedure Act, if you like. It's called Act 30. And the one I'm holding here is the 1992 Constitution. This is the Supreme Law of Ghana. And Act 30, if you like, we can say is on the back of this law. This is 1960. And this is 1993. So what's the point? Okay. This Constitution contains what you call the broad strokes of our law. And when we make laws in Parliament, legislation in Parliament, they flesh out the Constitution to provide for the detailed mechanics. Because if you want to provide for the detailed mechanics of every law or every institution or power established in the Constitution, then we may end up with a room, full of a Constitution. That's a volume of a Constitution that nobody can lift. So we make the Constitution which will contain the broad strokes, and then we make, acts of Parliament which will now flesh out the Constitution in detail as to how to implement the processes. Good example. The Constitution in Article 21, 1F, says that people have the right to know, as in right to information. Now, it doesn't say much about that. So we had to pass a Right to Information Act, 2019. In that act, we fleshed out in detail that all public institutions must, first of all, be proactive, publish their information to the public to know. But where the public has a need for some information which is not available, they can make a request. If they make a request, within 14 days, you should supply the information. If you can't supply the information, show them where and how. And if you don't or reject it, they can make an appeal to the head of the institution, who has a number of days to also make sure they either grant them or they don't grant them. If the head of the institution refuses them, they can make a further appeal to a complaint to the Right to Information Commission. The Right to Information Commission will deal with it. If they are unhappy about the process, they can go to a court. And it is step by step by step. The Constitution contains only the broad stroke. It's like a phrase, one sentence, but it takes the act to flesh it out. So that's how these acts do. So in our Constitution, in Article 19, Article 19 is useful for this discussion because in 19.3, it says, and I read, it says, and I read, Article 19.3 says that, so come along with me, you know, this is impromptu, but we can have a good discussion. 19.3 says that the trial of a person charged with a criminal offense shall take place in his presence. So we have highlighted charged. And thanks to Mami Nyamiche Thompson, immediately the issue came up. She said, the article that says charged. So a person who has been charged, if the person has not been charged, this provision is not about them. What does it mean for a person to be charged? Either you have been arrested by the police, a complaint has been made against you, they have invited you, police or any law enforcement agency. So let's be clear about that. Now, many of the law enforcement agencies, they have what we call police powers. So if you take OSP, they have police powers, the power to arrest, okay, and so on. Now, it says the trial of a person charged with a criminal offense shall take place in his presence. I want us to stop there. There is an unless, but you don't move to the unless, because that's like, if this does not work, then you move to here, right? So a person charged, note that the first thing that must happen is that the person has been charged with an offense, a criminal offense. The law says nothing is crime unless, it has been provided for in a written law. That is what you read in this Constitution. Nothing is crime unless it has been provided for in a written law and the sanction has been provided for. So once, for example, you have been said to have committed a road traffic offense, you have jumped the red light. You are not supposed to jump the red light. Once you jump it, you are caught. You have committed an infraction of the law. That's a criminal offense. There is a road traffic regulation. There's an act that says you shouldn't do that. But because you have done that, you have been caught. So you will be taken to a police station or a law enforcement place. Maybe you have stolen. Maybe you have hit somebody. You've assaulted. Or you've committed murder. You've committed whatever offense it is. You must first be charged. And you'll be charged with that particular offense. What the law says you shouldn't do, which you have done. You have been charged. You'll be charged by the police or whichever law enforcement organization it is. How do they go about charging a person? They will either bring you before them by an arrest, or they will invite you. In fact, when they invite you, it's practically an arrest. Or they will invite you. And then they will tell you, we are investigating a case of a road traffic offense. Maybe look at this picture, look at this, video. Are you the one who drove and, jammed the traffic? Look at this person who was lying in a pool of blood. Are you the one who hit him? This person complains that you came into their shop or came into his house. He had his mobile phone, you took it away. This mobile phone was found on you. Then they will ask you, what do you say? Then they will give you a piece of paper. Then you will write. They will say that you are being charged for XYZ offense. Then you will now write and say, well, I know something about it, but it's not exactly that I intended to steal or that I intended to jump the traffic. This is what happened. Maybe I lost my brakes and so on and so forth. Then you explain. Or you say, I know absolutely nothing about this situation. They call it cautioning. They caution you, you write your statement, and after that, because they have to take you to court, they will tell you that you are under arrest. Then you ask them to give you bail. Sometimes they themselves will say, you are under arrest, but we'll process you for bail. Then they will grant you bail. The police can do that, or any law enforcement or agency can do that. They can grant you bail. We call it police inquiry bail. But if they don't grant you bail, according to Article 14, within 48 hours, they must produce you before a court if they have not released you. And then before the court, you will now ask for bail. You will be charged properly. Then the court will ask you to plead. They'll say, you were found to have done ABC on so and so date around Kokomlemle, so and so. You hit somebody and you killed them and you ran or you stole, somebody's phone. And then the court will ask you, this is what the prosecution say you have done. How do you plead? Then you say, I'm guilty, if you think truly that you are guilty. Or you say, I'm not guilty, right? Once you say you are guilty, this process will go on very fast because you'll be convicted on your own plea. Except that if it's a matter of murder, when you say you are guilty, the law says you are not going to have, a trial like that and then because you have pleaded guilty. The court will still ensure that there's a full trial for you as if you were not guilty until the end. So if it's not murder, you go through the whole process. So after you plead, then bail will be granted you. The bail has conditions. They may take your travel documents. They may say, do this, do that. If you don't do that, then you can't get out of bail. And we have treated bail here. Bail is discretionary, even though it's available for any and every offense. It's discretionary. It's at the discretion of the court and granted on conditions. So once you do that, you are granted bail either by the police or later by the court. Then a trial will begin in due course. A few things will happen, then a trial will begin. If the trial is going on, for example, and you are not around, you have run away, you have absconded, they are looking for you, they can't find you, the court will issue a bench warrant. You always hear about it, that somebody was in court the first day, was in court the next day, the other day they went, he wasn't there. Then the judges will issue what is called a bench warrant for your arrest. So they use the bench warrant, they look for you, they can't find you. If they can't find you, the court will say they are able to proceed without you. Have you heard about the Sedina case? The former Maslock boss under the NDC. She was charged with some other in the court. In the course of the trial, she sought to, travel, I think for medical attention or something like that. She never came back. That doesn't mean the trial will not continue. So the trial continued in her absence. In the end, she was convicted. And now processes have been invoked to get her to come and be put into prison to face the consequences of the offense. You may have heard about the case of Benjilo, right? The trial was going on, and then two of them escaped. They ran away, they absconded, they couldn't be found. The trial had to continue because you can't stop it. After you try to look for you and they can't find you, it has to continue. And in that process, at the end, a verdict or a judgment will be given, and then you'll be looked for and put in jail. That is the beginning. It says, the trial of a person charged with a criminal offense shall take place in his presence. You must be present, but you must have been charged. Then it says, unless A, that person refuses to appear before the court for the trial to be conducted in his presence after he has been duly notified of the trial, or he conducts himself in such a manner as to render the continuation of the proceedings in his presence impracticable, and the court orders him to be removed for trial to proceed in his absence. So if you abscond, it means you have your conduct is such that you are making the trial in your presence impracticable. So one of the ways you can be charged is either you have been arrested and brought before a police or a law enforcement and you are charged. Another way by which you can face a charge is that a complaint is made, a summons is issued after you, normally from a magistrate, normally, but not always. Then the summons requires you to make yourself available so that you will face the proper charges. Well, if you don't make yourself available, guess what? There will be a warrant for your arrest to compel you to show up. If you don't show up, the summons will be served on you. So when the summons is issued, it will be directed at you. Police officers will have to look for you to serve you. If you are a civil servant, it could be brought to your head of department, and your head of department must look for you and give it to you. That is service. If all of that, they try, they can't find you, they may then do something. They can look for your place of abode, your last place of abode, which is known to the law enforcement people. And then they'll go there, they'll look for someone who is of 18 years and above, deemed to be adults. Then they will dump a copy with them, and that will be deemed that you have become aware. If that is also not the process, they can affix it on the premises, on the building. You see, sometimes they post court processes on buildings. That is also one way by which they can bring the summons to our attention. But at every time, at the beginning of a criminal process, your physical presence is required. It is not done away with unless the two instances have, occasioned that you have absconded, you have run away, or that you have already presented yourself, but you are making it impossible and impractical for the trial to continue in your presence. So the court can say, we let you go, we don't want you in the courtroom, we'll continue with the trial. Whatever the case is, the law's requirement is that you must be aware that you have already been charged with an offense. You must be aware of it. You must be aware that there's a trial that is going on against you. Without these processes, any trial in your absence is like void and is easily set aside in law. Now, I would like to go up the slide and show you another point that I want to make. Apart from the constitutional provision, I told you that the Constitution carries the broad strokes, but these ones, the Acts of Parliament, are used to, as it were, flesh out the law. I'm going to read to you a provision of the law. It is section 167 of the Criminal and Other Offences Act Procedure Code, section 167. I'm going to read that to you. 167 is titled Non-Appearance of Accused. I read, where the accused does not appear personally, where the accused does not appear personally and does not plead guilty in writing or by counsel under section 70, the court shall issue a warrant to arrest the accused and cause the accused to be brought before the court as provided under Section 72. Right. Where the accused does not appear personally and does not plead guilty, you, the accused, you have not appeared personally. You have also not pleaded guilty in writing or by your lawyer. In that case, the court will issue a warrant to arrest you and cause you to be brought to the court. But guess what? That provision is subject to a Section 70 and a Section 72. This is Section 167 I'm reading to you. It says, if you choose to plead guilty in writing or ask your lawyer to plead guilty in writing, your appearance may be excused. So we can go on and finish the matter. We don't need you because you have written to plead guilty or you have, through your lawyer, pleaded guilty. But guess what Section 70 says? 70 says, whenever a district magistrate issues a summons in respect of any offense other than a felony, felonies, murder, treason, those things, they are serious offenses, they are felonies. He may, if he sees reason to do so, and shall, when the offense with which the accused is charged is punishable only by a fine or by imprisonment not exceeding 3 months, dispense with the personal attendance of the accused, provided that he pleads guilty in writing or appears by an advocate. So there is a time in our criminal process where your personal attendance can be excused. Remember, by Section 167 and 70 of Act 30, you don't make that decision. It is the court that makes that decision. But guess what? It's not for every offense. It's not for a serious offense. It says an offense for which the punishment, that's the ultimate punishment you suffer, will be 3 months. The judge can say, oh, look, we don't need the person to come. It's a 3 months imprisonment that the person is supposed to suffer, and we can actually give them a fine. So we give them a fine, and that is it. We don't want them to be here in the courtroom. Their lawyer has been here. Or they have written to say they are guilty. Remember, first, you, the accused person, charged with that offense, which is not a felony, and which is punishable by a fine and imprisonment not more than 3 months. You must have already written to say, I am guilty. If you write to say you are guilty, it means you have already been charged. You know your charge. That's why you say you are guilty. It means you have been cautioned. So either you write or your lawyer appears to say you are guilty. Once you say you are guilty, and it is about an offense which attracts the maximum of only 3 months imprisonment or just a fine, and it's not a felony, then the judge can decide that they dispense with your appearance. You don't need to appear. Otherwise, like you read in Article 19.3, your presence is mandatory. You must be present. So, for want of time, that will be just, let's call it, a curtain raiser to introduce you to what our laws are. You don't have the option to choose for yourself and say, I hit someone at the Araga Junction at Oforukrom. I can drive away and go. The police should go to court without me. You can't say that. It doesn't work. Yeah, it doesn't work. They will look for you. there'll be a warrant for your arrest if they can't find you. And when you are arrested and brought before the court, you will have to be bailed. When you are giving bail, there'll be conditions. The conditions limit your movements, and then there'll be a trial. But as the law says, if they can't find you, they'll go through a summons, they'll go through processes, and when you have absconded, or it becomes impracticable to have a trial in your presence, once you have been charged, then there could be a trial in your absence. But if it is an offense for which, in the end, you go to jail for a maximum of only 3 months, then also you can write to plead guilty or through your lawyer. And by that process, a judge can say, I dispense with your attendance. It's not you nominating to dispense with your attendance. And if a judge says so, if they are giving you a fine, the law says if they give you the fine and nominate a period within which you should pay, and you have not paid, they can change their mind and issue a summons for you to come and show cause why you should not, as it were, be brought before the court and sentenced and put into jail. So trial in absentia is permitted, but under very slim circumstances, only 2. And in all circumstances, there must be a charge. Without a charge first, there cannot be a trial without in absentia. There must be a charge. Either you are brought for the charge by an arrest, or you are brought to be charged by a summons. Through a warrant, the law enforcement agencies are able to declare you wanted. And Interpol is one of the organizations that assist globally for people who are running away from justice to be arrested and brought to face justice. If this is not the case, what is likely to happen is that I'll commit murder. I'll just run away and say, go ahead and try me. You try me in my absence, you convict me, I'm still not there. So on paper, I've been tried, I've been convicted, I've been sentenced to death, but I'm chilling and cooling off somewhere. I can steal as much as I want, state funds or whatever it is, and then say, well, since they're trying absentia, go and try me. I will make myself available. So go on. It is not done that way. All right, so we'll take a quick break. I'll be joined by Isabel Boateng, president of the Accra Bar, to understand the matter of the future fit lawyer, embracing technology and service. That is for the Law Week by the Bar Association in Accra. And on behalf of Genevieve Shelley-Lardy, the Executive Secretary of the Right to Information Commission, I render her apologies for not being able to show up for the first segment, but I hope I've been helpful to you in explaining trial in absentia. We'll be right back. You're welcome back. This is the law. It's your legal light. It is your help law. And as we advertise, right here in the studio is Madam President, President of the Ghana Bar Association, Greater Accra, Isabel Boateng. Thank you so very much for making time to honor our invitation.
Thank you very much, Samson, for having me.
Great to have you. So, this is Novel, a law week for the lawyers in Accra. And the heading or the topic is the Future Fit Lawyer, Embracing Technology, Entrepreneurship, Excellence and Service to the Community. First of all, what's the idea? What's the Law Week about? We know we do Law Weeks when we are in school. What's the Law Week about?
Okay. So Samson, just to provide some context, because everything is not everything is done not in a vacuum.
That's right.
So we are all experiencing a fragmented world, changing dynamics, the disruption of technology. And what we say at the regional level is that you have one of three choices in terms of your response. You can wring your fingers in desperation. You can say this has happened upon us, or you can respond intentionally, purposefully, and strategize to see how you can leverage all of these changes to create opportunities for yourself as a lawyer, opportunities for your law firm. And this cuts across. It's not only in private sector, whether you work in the public sector, whether you're in academia, whether you work in a legal department, all of these things that are happening around us is an opportunity for us to leverage and to strategize and to make impact. So what we are saying for this Law Week is that in terms of all the things that are going around us, the key things that we think are important to note are technology, our entrepreneurship, our dedication to service and to our community. And we wanted to focus on that. You know that we always say everybody's talking about AI, everybody's talking about digitization, but the key thing is we all are talking about it, but what are we doing about it?
Right.
We need to plan, we need to think ahead, and this Law Week is going to focus on several key issues that we think that lawyers at all levels, it's not just for young lawyers, it's for seasoned lawyers, it's for the newly minted lawyer, it's for everybody. Come, let's change our mindsets, let's learn, let's enhance our knowledge, and let's take the steps that we need to transform our bar and our profession.
Great. So this Law Week, what exactly is going to be happening, before we talk about the dates, what exactly is going to be happening within the Law Week? It's a concept many are embracing, and there are many lawyers I've encountered who say, okay, so we told you you went on a post to be president. People felt you were a blessing to the bar, and so there's no actually point for anybody contesting you. You have a very successful practice, and you are coming in to serve. Now they are seeing the results. One of the ways to show is this process. What's in it in the Law Week?
Okay. So first of all, I want to say that it's always very humbling when I hear anybody say that. But I believe that leadership is a gift. It's a gift to give of yourself, and it's a gift to impact. And that is not a gift that everybody gets. So when you get it, you need to run with it. You need to do the best you can. That is humanly possible. So that's my belief. And with this Law Week, we have three key things that we want to emphasize. So we're going to have a full-day conference. And that full-day conference, of course, we're going to have some of the formalities, leaders of the bar coming to speak to us. We are also going to do something
Many lawyers have joined us, particularly for today's edition. Please make these notes. They are important to you.
Thank you. So one of the key things that will happen on the first day, this is July 2nd of the conference, is that we have come into a partnership with the Legal Aid Commission. We are all aware of the number of lawyers that we are churning out each year. Now, some of these lawyers, they don't have anywhere to do pupillage. At the same time, you have a gap with the Legal Aid Commission where you don't have enough resources to be able to attend to all the matters that they are engulfed with every day. So why not come into a partnership that says that our young lawyers can volunteer, use that as a route to pupillage. We have senior lawyers who will supervise. We are not trying to suggest that because it's legal aid, we are throwing at them lawyers who have not really experienced the law in itself.
That's right.
But what we are saying is that they will be overseen by senior lawyers. So that provides a win-win situation where these young lawyers get the opportunity to get to set their teeth into the law, and then also legal aid, we're able to sort of consolidate the work that we're doing. Right. So that will be a key thing of that first day. Then we're going to have...
This is the 2nd of July.
That's the 2nd of July.
Right.
Then we're going to have 3 CLEs, very impactful. The first CLE is going to be talking about AI, how the world will be in 2030. Like I said earlier, we don't say that the world should happen upon us. You are prepared. If you are thinking about the future, you think about it today, you plan today, not tomorrow. So we're going to talk about AI, how AI is affecting our legal space. We're going to talk about how we can leverage AI so that we don't become, as some people are afraid of, that we don't become obsolete. That's not the plan. Yeah. But how do you ensure that even with the way AI is going, the lawyer still provides value to the client.
That's right.
There are many ways: personal development, being client-centric, being a business advisor instead of being a lawyer only. There are different ways, and we want us to start to think about it so that we'll be prepared. We'll also be talking to a cross-section of lawyers across generations, how we can become relevant. And they'll be telling the stories from their personal and professional development, because as human beings, we're not just one-sided. We're not just lawyers, we're human beings.
The life of the law is experience.
It's experience, exactly. The life of the law is experience. Then lastly, we'll be talking also about service to community, piggybacking on legal aid, what the launch that we would have done, and also reminding us of our consciousness to our communities.
Okay.
A lot of lawyers are becoming we are just becoming too self. So how do we contribute to our community? And then we're also going to have legal clinics. There's going to be outreach. We're going to have one at Ifwa Sutherland Park. We're going to have one at Ashaiman Laurie Park. And then Samson here has kindly volunteered. Samson chairs our prisons outreach work, and he will be doing the work for us in the prison. I really am grateful to you, Samson, for taking up on that great responsibility.
You mentioned the outreach work. Ifwa Sutherland Park. What is it? What's the nature?
Okay. So we're going to have lawyers who have volunteered. We're going to invite the general public. We're going to have a sort of like a scheme in terms of the kinds of matters that can be brought there. And we're going to have lawyers there to be able to speak to the general public, give advice on certain matters that we can resolve immediately. Lawyers who decide to want to help beyond that day can also do that. So that's what's going to happen. And then we are going to have on July 5th, we're going to have a themed dinner dance.
Hold on with that. So the outreach and Ifwa Sutherland Park, if I'm watching now and I'm listening now and I have some legal issue, I can be getting ready to show up at Ifwa Sutherland Park because there will be hordes of lawyers ready to assist me for free.
Exactly, Samson.
Okay.
That is what we will be doing.
When will this happen?
Okay, so this will happen on July 3rd. From 9 a.m. to 4 a.m. To 4 p.m.
That's almost like a whole day.
9 a.m. to 4 p.m.
Okay.
So they'll be there, just to repeat the sites again, Ifwa Sutherland Park, Ashaiman Laurie Station, and then Samson will help us, in Sawam prisons.
Great. So the Ashaiman Laurie Park, Ifwa Sutherland Park, also the two places. As for the Sawam prisons, a team of us will be going there to attend to, our friends who unfortunately find themselves there and need some help. We can give some help and then also speak to them in a manner that will be helpful to them as well. So on the 3rd of July, please mark that in your calendar. If you need the services of a lawyer and for a while now you just feel that you can't afford it, this is free for you. Just take advantage. Come to Ifwa Sutherland Park from 9 a.m. till 4 p.m. or the Ashaiman Laurie Park from 9 a.m. to 4 p.m. and there will be lawyers, the best of lawyers, to assist you resolve your issues at no cost. Then you now bring in that part.
Yes. So, Samson, to crown it all, I think it's important to let our hair down.
Right.
And to enjoy ourselves, to network, to remind ourselves that after a hard day's work, it's good to laugh. We are also thinking about inviting people from other industries so that there will be some engagement with industry.
That's the industry engagement.
Yes, the industry engagement, so that we have people coming in and so that we can chit-chat. It's always good to share ideas with people outside your normal routine every day. So that would also happen. It will be black tie. It will be an opportunity for us to dress up.
It's always black tie. What's wrong with you lawyers? Always black tie.
Yes, this time.
All right.
Yeah, so it will be an interesting one.
Okay.
And I just want to also say a big thanks to some of the organizations that have supported us right now. GT Bank has supported us. AB and Dave, which is my own law firm, Benton, Inchul, Leche, and Kuma. Templars have supported us. CPL Construction has supported us. So I just want to say thank you. Casa Preco supporting us. So we hope that we're asking for more support so that we can have a really wonderful law week. That will be more.
So there will be 2 days where there will be engagement amongst lawyers, young lawyers, experienced lawyers, lawyers with industry. That will be at a dinner session. So there will be the 2nd of July,
Yes.
and there will be the 5th of
Yes.
July.
Yes.
These are the 2 occasions where the lawyers will
Yes.
interact.
Yes. Yes.
Okay.
Yes.
So on the first occasion, what's the venue?
So on the first occasion, the venue is the Accra International Conference Center.
Big enough.
Big enough. Then on the 5th, also Accra International Conference Center, but at the Grand Arena. That's where we'll have the dinner.
Right. Yes. So it's your invitation to all lawyers, young and old,
Yes.
to find themselves at the Accra International Conference Center on the 2nd
Yes.
of July.
Yes.
Starts at what time?
It starts at 9 a.m.
9 a.m.
and at 4 p.m.
Okay. So 9 a.m., not Ghana time.
Not Ghana time.
Right. It's the your no-nonsense judges time. No-nonsense judges like if you are as I would say their time. When they say 9, you have to be there 9. If you are not there at 9, you are in trouble. So 9 o'clock at the Accra International Conference Center, that will be the opening.
Yes.
And the various CLEs that you're talking
Yes.
about, the opportunity to get to learn
Yes.
how you can interact with AI,
Yes.
to use it to help your profession, and also interact with senior lawyers who share experience and so on and so forth.
Exactly.
If somebody misses this, what would you tell them?
I think I'll tell them that was such a humongous miss. Such a humongous miss.
Okay.
Because you know, we need to conscientize ourselves. We need to have a transformational mindset.
Right.
And sometimes the reason why people don't have that is because they don't have the information concretely.
Okay.
We all know about AI, but let's come and really learn what is it about and how can I strategize.
Right.
I think it will be an amazing week, and I'm asking all members, take the time to please come. It could be life-changing.
Right.
Don't sit on the fences.
Right. But before they come, what are they supposed to do? Are they supposed to reach out to a line or something? Are they supposed to do something or?
Yes.
Yeah.
So we have a registration link. Members can register. There's a fee for it. But I must say that we've had feedback. And if, as at the regional bar, we said our whole agenda is to be a people-centered, responsive association. So we've had the feedback, especially from young lawyers, in terms of the pricing. And I must say that we tried to work all the magic we could to make sure that in addition to getting sponsorship and using some of our dues to subsidize, we would keep it at a certain low level. But we are still hearing voices that say, we still can't afford it. We're going to go back to the drawing table and we're going to come back to them because this is for all of us. There's no point having a great sessions and we don't have as many people turning up.
But as you said, it's unmissable. And like they say, this is like one brief consultation session. You pay in excess. So what's the problem? I have can I pick about 2-3 calls? And I'm asking my... Okay, my producer says no, I can't.
Samson, can I say one last thing?
Please go on.
As a preface to the Law Week, you know, the Martyrs Day, the National Bar Association is leading the Martyrs Day celebration. But as a regional bar, we want to encourage our members, please, let's attend. It's at Accra Rich Church, and it starts at 10 a.m. Please, let's show up in our numbers. And I hope that we'll see you there as a prelude to the Law Week.
Great. The idea of the Law Week has been embraced by many people. Many are so excited about it, and it is themed the Future Fit Lawyer, embracing technology, number one, which is very central, and experts who have what it takes to give you that education how to merge technology into your practice. Because really, without knowing your way and the technological skills, you are actually just, shipping yourself out of the industry. There are fears that, AI is going to take over. So you better get to catch it. Entrepreneurship, and Madam President speaks about, bringing industry to interact as well. Excellence and service to community. Service to community, remember, on the 3rd of July at the Ifwa Sutherland Park, Children's Park, from 9 a.m. till 4 p.m. and at the Sherman Park, all lawyers, we're going to have to make ourselves available there to serve our community. People who have a need for lawyer but can't afford will all come there, and then we will assist them. So all of you who are watching and listening who have one issue or the other, we are directing you to the Ifwa Sutherland Park on the 3rd of July, 9 a.m. to 4 p.m. and at the Sherman Laurie Park as well. Okay, so for all the programs, there is 9 to 4 p.m. Is that how it is?
So 9 to 4 p.m. for the 2nd of July, which is the conference with the CLEs, and then the legal clinics. And then on the July 5th, which is the dinner dance, that starts at 6:30.
Okay. Once again, remember that Madam President says the time she gives you is a time by one of your no-nonsense judges. So you must comply with the time. Thank you so very much. Isabel Boateng is the president of the Ghana Bar Association Greater Accra, and she joined us to shed more light on the maiden edition of the Law Week for all lawyers who are in Accra. Thank you very much. Okay. I got a message for you, but I'll give it to you privately. All right, thank you all very much. This has been The Law. It's your legal light. It is your help law. I'm Samson Lardy Anyenini. Join us again Sunday, same time, for another edition. But of course, tomorrow at 11 o'clock, you can join the show once again.